It appears that I made a mistake.
What about the jurors in lunch? How long do you think this will be? Jurors, I instruct you that those holes were made by the criminalist.
Karen Reed's retrial in week number 8 is seeing a lot of adversity. One of the craziest things that's happened, I think, so far in the trial is Hank Brennan, I believe, misleading the jury, even though he claims it's a mistake. Let's ask you what you think. And this week, I have a special guest to help us. It is week 8 of the Karen Reed retrial. I'm Andrew Myers. This is About the Law. Joining me, Lindsay. Hi, Lindsay. Thanks for joining me.
Hi, Andrew. Thank you so much for having me. Excited to be here.
How are you?
Doing well. Really enjoying watching the fireworks. It's not even 4th of July yet. Not
yet. But in the courtroom, I know exactly what you're talking about. You follow true crime. I know that. And like everybody else in Massachusetts, your ear is to the ground on this one, right?
Yeah, I don't think you can be in this state right now and not be constantly hearing about it. And it's been a pretty dramatic one at that.
It has. One of the key witnesses that people have been looking forward to in this case is the ARCA experts. They're the experts that were originally hired by the FBI, although we're not allowed to say that. For whatever reason, the court has said we're not going to mention that it was the FBI that did an investigation and hired the ARCA experts. But nonetheless, Dr. Daniel Wolf from ARCA was on the witness stand, and he was being cross-examined by the special prosecutor, Hank Brennan, who looked like, in my mind anyhow, I think he was crossing the line between simple cross-examination and badgering the witness. Again, that's my view. Brennan claiming that scientific recreations by ARCA of whatever happened the night of January 28th, 29th, and 2022 was, in his view, not accurately portrayed by ARCA, because he feels they were, in this instance, they didn't use the right material in their sweatshirt. They didn't take into account whether it was new or old, had been through the dryer a number of times, or whether the sweatshirt was tight or not tight.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics and cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion. Putting aside Dr. Welcher or Dr. Rentschler, you have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes, and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
There are a couple of different ways to cross-examine a witness. You can be aggressive with them, but that's really going to, make them be on notice that, I got to pay attention to every word and mark my words. The other way to cross-examine, there are a lot of ways to do it. The other approach is to be more friendly. I've seen attorneys opposing counsel, fortunately or unfortunately, set the person at ease, give us some background, tell us a little bit about yourself. And then once they get the witness at ease, then they go for the punch. I've found the latter way more effective. How did you see it in terms of Brennan just being so aggressive, Lindsay?
For me, again, just with my background in mindfulness, I'm paying attention to their presence. And for me, what was a stark, what's really truly stood out for me is the stark difference between Brennan's elevated questioning. Clearly, his voice sounds frustrated. And then you have Dr. Wolf, who just remains unflappable. At one point, you can see even like a light smile on his face. And it's just this very remarkable contrast between cool, calm, collected, presenting logic versus what Brennan is doing, which just has this like elevated, irritated tone to his voice. I mean, I can't see him obviously, but that's how he's presenting.
Yeah, I think you put it quite well. I mean, he was trying, Hank Brennan was, to get under Wolf's skin, and he wanted to be able to be in control. But it seems like it was the other way around. Dr. Wolf was cool, calm, composed, was able to formulate fairly quickly a good answer. And Brennan was getting more and more aggravated and frustrating that he wasn't being able to get under Dr. Wolf's skin. I mean, it was really a contrast. And I was kind of surprised because Brennan's been around for a while. He started out as a prosecutor, and then he switched over to defense attorney. Now he's back in the role of a prosecutor. So I was kind of surprised that he got so frustrated, and he really wasn't getting much of a result. The real problem came when Brennan picked up in a display case John O'Keefe's sweatshirt that he was wearing the night of January 29th when events took place. And he held it up in front of not only the judge and the witness, but the jury, implying that holes cut in the back were caused by the events of that night, when in reality, that's not true at all. They were cut by a lab technician.
I'll direct you to here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
So Karen Reed's defense attorneys immediately called for a mistrial. Robert Alessi arguing that Brennan's questioning and inference was one of intentional misconduct, the manufacture of evidence that could only be fixed by granting a mistrial.
Here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get back to this in a moment. But I would like to do it, and certainly entertain any of your other questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think.
Isn't that something that the prosecution was given 6 weeks to put their trial on? And little interruption. But now that the defense gets their turn and they're making some important point, what about the lunch for the jurors?
It does. It really does stand out as we're discussing something pretty dramatic that that's her response. And I can only go from my background as somebody who kind of studies people and spends a lot of time with people. There's a level of caretaking that I think might be present for the judge, but it feels as though she's like coddling the jury at the expense of the defense. It's an interesting dynamic to watch her continue to talk about the jury. The jury, we're wasting their time. It's interesting to watch her dynamic with them.
That's exactly one of the things that she said. She said she didn't want to waste their time. And she said that, and of course, the jury wasn't in the room when she made all these statements, but she had also on this very same day said, from looking at the jury, they're very fed up. Correct me if I'm wrong, the implication being that the defense attorneys are just wasting the jury's time when, the state, the Commonwealth, Hank Brennan had 6 full weeks to do pretty much whatever he wanted. He could drag on whatever witnesses he wanted and take as long as he wanted to take. But we only hear about the jury being frustrated and the jury, being fed up when the defense is up and the defense wants to raise points that rise to constitutional implications. The defendant has an absolute right to a fair trial, and the defense has an absolute right to bring all good faith evidence and to foster a strong defense. So I just found it, I'll say it, disingenuous for the judge to, you want to hurry up, Mr. Alessi, the jury needs their lunch. I found that disingenuous. All right, let's finish up and see, this is the rest of Mr. Alessi's argument that he was told to hurry up on for mistrial.
This will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you.
Okay.
Go ahead, Mr. Alessi.
Thank you, Your Honor. So I just want to get the flow back going here and the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the.
By the way, for people that hadn't watched the whole thing, he's wearing those gloves because those are evidence gloves. When he took the John O'Keefe sweatshirt out of the plexiglass containment, he would have been touching it, so he had to have evidence gloves. He's not doing it to be dramatic. He's not doing it for any other reason than if you touch evidence, you need to have evidence gloves on.
Hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after. Remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
I'm offended by that she kept interrupting Attorney Alessi. Where's the doc? He wouldn't let him finish his argument. She stopped him several times, whereas Hank Brennan generally is allowed to continue arguing. But moreover, in my mind, this is a really major issue in that moment that the Commonwealth claims that Cameron Reed backed into John O'Keefe. What happened? And for a prosecutor to improperly and incorrectly mislead the jury into thinking that those tears in the back of the sweatshirt were caused by that alleged collision and weren't cut by the lab technician, to me, that's major. To me, that's a big point.
Absolutely. And again, I'm just paying attention to body language, tone of voice. You could see the defense getting frustrated in that they're losing their stream, they're losing their focus. You know, I wanted to be like, take a breath, recenter himself, go back, but it was hard. He had to keep stop, start. And then I can hear the exasperation in the judge's voice, which clearly, I mean, we know that body language, tone of voice communicates far more than just the words we're saying. And so she, again, has this demeanor that is very dismissive of their side.
It's been that way all the way along a lot. It's really interesting to hear your point of view on that, because we've all, people I've had on the podcast and, other observers all over the YouTubosphere, as I call it, they're looking at it from a legal point of view, from the point of view of the rulings that have been made all along. For example, one of the rulings was the defense brought on a pathologist, and she limited her testimony and tried to keep her from talking about whether it was dog bites that were on John O'Keefe's side. So and we could go on and on and on, and a lot of rulings like that. But I think it's interesting to hear you say that, because it's beyond belief. It's just beyond belief. Brennan, offered no self-defense. All he did is he said, "No, it was a mistake," and then he proposed,
My bad.
My bad. It was just a mistake. And this is major. This isn't like, oh, I dropped a pencil on the floor, I'm sorry. Or like before we had a couple of technical problems today before we did the podcast. We both apologize. There's no big deal. We go on with our lives. But, I don't know if I buy that it was a mistake. I really don't. All he did was he said, it's a mistake. And he had an idea, here, Judge, here's how we're going to solve the problem.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
I don't know about you, but I thought it was hard to tell because the camera angle was, we can't control it. Did you notice? I thought I noticed his hands trembling a little bit when he first started to speak. Did you notice anything like that, or am I not on key on that one?
His body language to me was really interesting. This very inward turning, shoulders slumped, looking to the side. That confident, somewhat cocky, sarcastic demeanor is gone, and now it's a very different tone of voice.
Okay. So the other question I have for you, and I'll give you my answer, and you don't have to agree with me. Do you agree with him that it was a mistake, just a simple mistake, or I think it was an intentional move to mislead the jury? And the reason I say that is because, he's been making, so far, he's been paid almost $250,000 to step in as the special prosecutor. Initially, he said he hadn't watched the whole first trial. I can't believe that. He's got a staff. He's got people both in his own office, and he's able to, tap into the resources of the Norfolk County District Attorney, presumably. So I don't believe that he didn't know that those cuts in the sweatshirt were made by a lab technician. I don't believe it's a simple mistake. Correct me if I'm wrong.
Well, I can't obviously speak to what's in the hearts and the minds of this man, but I was more taken aback by how quickly he just moved to this is how you fix it. Like
Yeah.
the end. To me, if that is a truly mistaken, big glaring mistake in your case, there's a bit more humility, but that was not present. So
I think he just wanted to put a Band-Aid on it and walk away from it because he knew that the judge would, in all likelihood, he knew that the whole thing would blow over if he just like tried to gloss over it. I was actually while this was going on live, I was sitting at my desk trying to get some work done, but I had it on a monitor in my office, and I was actually texting back and forth with a friend before we knew what was going to happen, and I went back and forth with her and I said, she's not going to grant the mistrial. Do you want to bet against me? She's like, no, she's not. I mean, anyone who's viewed a little bit of this trial knew that she was not going to grant a mistrial.
right, of course. But it really is pretty, even just to the layperson, pretty shocking that a prosecutor can make such a grievous error and just, like we joked, like, my bad, and just move on. It's mind-blowing to me.
Yeah, me too. And whether it was a mistake or, as I think, an intentional move to mislead the jury, the judge gave a very hurried curative instruction to the jury in less than 25 seconds and mixed it in with a rush towards the lunch hour.
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think Mr. Yannetti, your next witness, please.
Oh, goodness.
Yeah, so lunch is more important than setting the jury straight. And I just always question. I mean, I am an attorney. I've tried a lot of cases, and I always question. I mean, yes, we have to take jury instructions seriously. Yes, we have to go back and forth and agree or have the judge resolve our differences in a good, fair, law-based jury instruction. But I always question, when the jury goes back into the jury room after, as we think it's going to be 8 weeks worth of testimony, are they going to remember not only all the evidence, but all these instructions? I mean, in the end, the judge is going to give them additional instructions. So I question whether the instruction is really going to carry a lot of weight with the jury. I really don't know. What do you think?
Yeah, that goes to how much they can actually absorb and take in, and they are just humans. I mean, again, just as the layperson, most of us, I'm using my professional experience, when we practice meditation, we can maybe be present for 5 seconds and the brain goes on to something else. And then the brain goes on to something else. And then you bring it back and the brain goes on to something else. Ooh, look, something shiny, right? So that's how our brains work. And with constant practice of mindful meditation, we might get it up to like 7 seconds. So just utilizing that as my base case, it's like, they're going to miss a lot of instruction. They're going to miss a lot of information. They are going to miss key points. And so that's where, it seems it could be a calculated risk. I'm going to throw this against the wall, see if it sticks, see if that piece of information lands. If it doesn't, and they just say later, like, oh, don't think about that. Maybe that's the piece they forget. I mean, this is part of, obviously, better than I, what you risk when you're trying a case. What information will land? Who knows?
No, that's an interesting perspective that you just gave us. That a really interesting perspective. And the analogy that you just gave of throwing enough up on the wall to see what sticks, that's something that defense attorneys say. That's something that both, insurance defense attorneys say in civil cases, but also criminal defense attorneys. Sometimes you're flailing, sometimes you're, hit with a wall of evidence, and you're only thoughts, your only strategy is just throw as much as you can up on the wall and see what sticks. So, that was interesting that you put it that way because, Hank Brennan, for much of his career, has been a big-time defense attorney. We all know he defended Whitey Bulger. And so I appreciated your perspective on that. My perspective is more along the lines of, they've been sitting there 8 weeks. Now, when you go to college and grad school, as you and I both know, a lot of material is thrown at you. And at the midterm, it's not even 8 weeks. You've got to go back and look at your notes from day one, week 2, week 3, and you realize, at least I wasn't the best student. I will admit it. In the end, I always pulled it together and graduated top 10%, but I wasn't the greatest student. I would have to go back and look at my notes from week 1, and I didn't even remember. I didn't remember what happened week 2. I didn't remember what happened week 3. How is this jury not only going to face deliberations going all the way back to the very first few witnesses, but then to remember all of these instructions, especially this one that was like, oh, don't pay. Oh, it's almost lunchtime. I don't know. So,
right. The jurors may not have heard the instruction because their stomachs were growling so loud. I don't know. But I think what you touched upon is something that I'm curious your opinion on in general when you have a jury, because that's the very human experience. I'm in grad school currently, and I read a chapter and I take a test 5 minutes later, and where did it go? And so that, I think, is a huge element here. Where now, remind me or correct me if I'm wrong. I think with the Alex Murdaugh trial, the jurors were not allowed to take notes, which I just thought that was completely wild. How on earth are you going to remember anything?
Yeah, that's nuts. That's nuts. And they weren't even given, as I won't speak for you, but when I was in law school, you were allowed to go out and buy outlines. And there are companies out there that write outlines in various legal topics like criminal law, constitutional law, negligence, all that stuff. But they're not even going to be allowed to do that. In this trial, they're allowed to take notes, and the reporters who are sitting along across the room, of course, the TV people are not allowed to show the faces of the jury. But more than one or two of the reporters that are sitting in the room right directly across from them in a very small courtroom have said that many of the jurors, except for one, are keeping really fastidious notes. So, I mean, unless you have a photographic memory or an eidetic memory like Sheldon, I mean, how do you remember? And I wouldn't want to have a guy like Sheldon on the jury because he's going to, well, don't you remember what they said in trial 1 and week 2? And, so I just don't know. I'm going to guess that a lot of the arguments are over what people remember and not the facts themselves.
Absolutely. And to me, just as somebody who came into this very, very unbiased, very much, let me hear both sides. I had no opinion going into this, and throughout the first trial, flipped back and forth. Oh, wow, that's really interesting. Oh my gosh, I can't believe this. So I don't want to say that I'm in either camp staunchly, but because of all of this, this seems like, regardless of my opinion of her guilt or innocence, there is a ton of reasonable doubt. It's just there. All of these things you've mentioned create doubt. I don't feel confident.
Oh, there's enough reasonable doubt in this case to, wallpaper New York City. I mean, it's just, there's, I don't even know where to start. You start with the investigation that they used the Solo cups, the brown shop and stop bags, the leaf blower. They didn't even find fragments of the taillight until days later after the vehicle had been found in the Sally Port. And, Chief Berkowitz and Brian Higgins were in there for an exceptionally long time. Now we had, in week 7, we had Kelly Devers, don't call me Devers, testify that it was a false memory when she said she saw the two. I mean, I could go on forever with the reasonable doubt that's been raised in this case. And so, that's one thing you and I agree on. I would ask our commenters, before we go to their comments, which is next, I would ask our commenters this question, and that is, was Mr. Brennan's waving the sweatshirt around and talking about the big, holes in the back. Was that a simple mistake, as he would allege, or was it an intentional move to try and convince the jury? So was it a mistake or was it intentional? So I'd just love to know, how our commenters see that one. Let's take a look at what our commenters are saying this week. Here we go. Comment number 10. We go backwards. Remember the old David Letterman show? We go backwards here.
Sure.
Comment number 10 from Emma Madaris. I think Proctor's texts do matter. They show complete disrespect for the defendant. And there's more reasonable doubt, like you were just saying. If you don't respect someone, you aren't going to care if they are treated fairly and humanely. She was clearly the enemy. How could any officer know there wasn't going to be any blowback unless he was the one making sure? And it goes to the bias of the lead investigator, Michael Proctor, who the prosecution has tried to back away from here in the retrial. And I mean, if the lead investigator is biased, there's more reasonable doubt for you.
Absolutely. Absolutely. Again, in my own practice, our whole basis is about curiosity, asking questions, to not believe your first thought. That is my whole career based on that. And this is why, because if your first thought is automatic, dislike, it shuts down all other possibilities. And then there's no other room for investigation, right? If you already have a snap judgment and you've decided from the jump that this is what it is. And
well, yeah, you're talking about curiosity. If for no other reason than curiosity, when John O'Keefe was found, passed away or in the throes of passing away on the front lawn of 34 Fairview, just if for no other reason than curiosity, shouldn't someone there have gone and knocked on the front door? Shouldn't some police officer, there were a bunch of them there, Saraf and Gallagher and a bunch of other, shouldn't one of them, just out of idle curiosity, is there anybody in here who knows the guy? Was he in here? Just out of idle curiosity, if not out of professional law enforcement investigative techniques, one or the other. But so, I mean, that's where the reasonable doubt started, right there the first day in those first moments. They did go into the house, but not until much later in the afternoon that day. And they just went into the front door of the rec room and left. Never went in the garage, never went in the basement, never explored the rest of the house. So I guess we've said enough about that one. This one's for you.
So from @Jane Cheeseman, love your thorough recaps. Good job, Andrew. Surely the jury will get it this time. The defense has put forward a stronger case of no collision. The CW, in my opinion, have actually put forward a weaker case. Just Brennan is more of a gaslighter.
Yeah, that's a common thought. A lot of people have said the same thing. And I think probably the worst example of that was the subject of this episode, the waving around of that sweatshirt with the holes in the back. Number 8, Kevin Denny. Out of all the BSers that have taken the stand, Kelly Dever is the most captivating. I have been watching all the recaps of her. Seeing her level of lying, petulance, and corruption doesn't get old.
Oof. I mean, social media just exploded with that one.
Well, as well it should. I mean, we're not in the old dark days where the only intake of news was, the 6 o'clock news and the newspaper. I mean, people have their thoughts immediately and they express them.
They sure do. At Brenna O'Brien, thank you for the continued coverage. Do you think KR's team, Karen Reed's team, should get the denial of Michael Easter and the denied mistrial in writing? I feel like having the rationale in writing versus oral denial is much more powerful. Not sure this is allowed. What are your thoughts and knowledge on this? Well, obviously.
Well, it is unusual. I mean, they're in the middle of a trial. A lot of things are happening. But I mean, what happened is the motion for reconsideration was filed, and I forget how many pages it was, but it was a lengthy motion that had an analysis of, okay, it's time to reconsider whether or not we should have this crime scene expert come on the stand. It had been denied before, but now we have all of this evidence that's come in through Lieutenant Gallagher and through Buchanan and the other officers who were there, saying, yeah, we did use a leaf blower. That's okay. And yeah, we didn't separate the witnesses, and that's okay. Well, it's not okay. So usually, as I've said before, so I'll make it as brief as I can, usually motions for reconsideration are denied. They're not favored, because in a motion to reconsider, you're kind of asking the court to admit that they're wrong and to, backpedal. But this wasn't the case this time, because what the motion for reconsideration said was, hey, please reconsider because there are new facts. These are things that have actually come out through law enforcement officers to the jury. And so let's reconsider bringing this crime scene expert in. And the judge never wrote, at least as we are now doing this episode, she's never written a decision. At the end of the midweek, in week 7, the jury was sent home, and the judge offhandedly said, is there anything else that you parties want me to do? Prosecution said no. Defense said, yeah, what about our motion that we filed? And she just put her hand up and said, denied. And no, that's not usual. It's very unusual. But you can't force the court to make a ruling. You can't force them. You can ask them. But I mean, if she doesn't want to write out a decision, she's not going to write out a decision. And often what judges do in these situations is they'll just write down on the margin denied. So I imagine that's what she did. It just, as at this time, it's not on the docket.
Well,
Anyhow.
just a follow-up question.
Yeah.
If for some reason Karen is convicted, does that lack of thorough response create room for appeal?
There are so many grounds for appeal. I wouldn't say that this in itself, because it's at the discretion of a judge to decide, how she wants to respond to a motion. And it is a motion for reconsideration. And she did write out her decision initially. So in itself, I don't think it's grounds for an appeal, but taken along with everything else and put in context with all the other things that we've seen in this case, yeah, I would put it on the bullet point in the appeal. Absolutely. So our next is from Norma Parrish, who says, Brennan tried to make it seem like no lights and Lucky could not see, but the plow has lots of lights and drivers are watching for people, animals, vehicles. And this talks about the great big huge snowplow that that Brian Loughran was driving, and that's a picture of the snowplow in the garage. So we don't get a good idea from this picture that it lit up like a Christmas tree. he could see everything. Okay, the next one is number 5.
Okay, at Lori Franklin EE4SH. If I were a juror, I'd be mad at the judge for quitting early, for wasting my time to even come in. At Lizika, she's like a lying divorced parent that always promises to change and that you matter more than anyone, then does the same thing again and again.
Sometimes I like the juxtaposition of a couple of different comments.
Yeah.
It's just kind of interesting. Okay, number 4, metonymy. I don't know if I pronounced these things right, but thank you, metonymy. I just keep going back to no bruises, especially watching what it looks like to get hit at 24 miles an hour. He was hit at multiple points, but he had no bruises below his chest. It's just beyond impossible. The whole case is insane. Everything keeps getting more and more ridiculous, and everyone in power seems to be completely incompetent or just freaking scary. We can say freaking, I think. There's other words. We can't say the other F word, but I think we can say freaking. YouTube has all these rules for things we can say and we can't say, but I think freaking is okay.
Yeah. All right. At Tina Ryan, 4023, evidence of the slightly broken taillight before Proctor got his hands on it should settle the case once and for all. Okay.
Yeah, and this goes to Sergeant Barrows from Dighton, who testified that when he observed Karen Leeds' Lexus being loaded up on a flatbed truck, the taillight was nowhere near as broken up and fractured up as when that vehicle was towed away in Dighton. If true, that is case ending for the Commonwealth. If true, that proves that the taillight was not broken in any kind of an alleged hit against allegedly John O'Keefe. when Karen Reed allegedly, purportedly backed into him. So, that was key testimony. He was a credible guy, and he's law enforcement testifying against law enforcement a town or two away. That's pretty much unheard of. That's really unheard of. Okay, Thomas FR8NX. I'm trying to think if there's some hidden meaning to that combination of letters and numbers. It's kind of like those vanity license plates. You're trying to figure out what people are trying to say. So if you have some kind of a message, I'm not sure. Anyhow, denial of defense expert regarding investigation is likely another reason for reversal due to denying defendant a vigorous defense. Most biased judge I've ever observed. And yeah, I kind of commented on this before. The denial of allowing the defense expert itself. It's a close call whether it in itself would be a successful grounds for appeal, but taken into account with everything else, if the defense has an expert and the expert could help the jury and shed light on an area that the jury itself would not otherwise, have as their own common knowledge. And if the expert, as this guy who worked for the FBI for years and years and years, had, a solid basis in education, training, and experience, in my view, he should have been allowed to testify. I mean, is it common to use a leaf blower?
Don't believe so.
No.
Hot take. What if the judge is not biased, but knows so clearly that this case is a disaster that she's just trying to move it through? She's just like, look, I know where this is going. Let's just get to the end.
I don't think you can say that because, you just don't know with a jury. I mean, you and I both have come into this from totally different angles. People have gotten furious with me. I'm used to it. I don't really care. People get mad at me all the time. But people get mad at me all the time because the very first podcasts I ever did on this 2 years ago, I had a co-host then who sadly has passed away, but he was firmly in the she did it camp. And, the more I read and watched and attended, actively watched the hearings, the motion to dismiss, the first one that was heard, and the other hearing, the evidentiary hearings, then the trial, I've come 180 degrees, just like opening my, it's okay to open your mind, it's our right. So I don't know. If she wants to move it along, she's only moving it along on the defense side. The prosecution side could take their jolly old time and, our witness isn't here, so let's take a day off. No way with the defense. She's just like, it's lunchtime. Hurry up, Mr. Alessi. We don't have time for your argument. So.
No, and of course I was being humorous, and I'm with you in the same camp that I've come into this very much bouncing back and forth between the sides. My initial take, we talked about this offline, was the old Occam's razor, like the simplest answers generally, that he got hit in the snow. I don't think they should have brought the level of charges that they brought. I mean, that to me was the first mistake, but that's just my personal opinion. Watching what has unfolded in terms of evidence, when we keep saying the same thing, it doesn't really matter except for if there's reasonable doubt, and there's just boatloads of that. So my personal opinion doesn't matter.
Well, it does matter because you are a resident of the Commonwealth and you're a thinking, intelligent person. And I mean, let's hope that they got thinking members of the Commonwealth, and let's hope that they got, thinking people on the jury. Let's just hope that they did. Okay, this is the last one, and you're doing the odd one, so it's your turn.
Oh, sure. Sean in the baby. Hope I got that one right. I really hope defense focuses their closing on the prosecution's burden of proof and weave the reasonable doubt in and out of that, because Brennan will burden shift to the maximum extent that he can without causing a mistrial with prejudice, which will never grant. I think the most important takeaway from Ronnie the juror's interview was that they fully burden shifted onto the defense and expect Karen to prove her innocence, and they deemed she failed.
Yeah, that's a good point, and a lot of people have pointed that out. When Hank was waving around that sweatshirt, which is the theme of this episode, and in other matters, he's tried to burden shift and they haven't proven this. Well, they haven't. That's not their point. The defense doesn't have to do anything. We all forget that under the Constitution of the United States, the defendant is presumed innocent until proven otherwise. And the defense doesn't have to do anything. They can just sit there. They can just sit there taking notes, twiddling their thumbs and doing nothing. But, typically what defense attorneys would do, a lot of times they don't put any witnesses on at all. What they do is raise reasonable doubt. Every time a law enforcement officer or other witness gets on the stand, they question it. They see holes in it. And in a case of this magnitude, a case that's this big, they have more opportunity. They have a lot more opportunity to raise reasonable doubt. And that's all that's required. But in this case, they've gone over and above that and presented just a ton of evidence. I really don't know. I really just, I don't know. I do think that, did you see the interview that Turtle Boy did with Ronnie, the juror?
No.
Okay,
I'm
well,
keep my opinions of that to myself.
Yeah, Ronnie, the juror, had said that essentially, and the interview went 3 hours, and I'm not going to do it justice in 20 seconds, but basically what it boiled down to was the jury saw that Karen was there, John was there. They thought it was proven that they did not go in the house. All the rest was just a distraction, so they found him guilty. Now, he was not of that view. He was a not guilty vote, but he asked questions about where the jury was, and that's pretty much what he said happened. It was a much lengthier interview than that, but that's what it boiled down to. I really appreciate you taking time out to talk to us. Do you want to, since this is your first appearance and hopefully not your last on our podcast, do you want to tell the audience just a little bit about your background?
Sure. As I hope it proved useful, or just at least a different take, I teach mindfulness. I look to support people with stress reduction, and in corporations that go in and lead workshops on managing stress. So as I've mentioned throughout this session, I'm paying attention more to the more subtle cues of what's happening in the body, the mind, the breath, the tone of voice. So that's my take on this. And so if that's something that interests you, happy to talk further.
Well, thanks a lot. My undergraduate degree before I went to law school was in mass communications, and communications occur on a lot of different levels. People know that. One level, and one level only, is what people say. But the other level is how they say it. And a lot of people aren't really aware of that. A lot of people like yourself are very aware of it, but most people aren't really aware that, the tone of voice, the posture, the inflection, the way they put sentences together. And trust me, attorneys know all of this, and they pattern themselves to understand that their communications are spoken and written, and that's only one level. So your input's great. Your input is really important. And I just wonder, how the jury will take all of this. So I would look forward to having your input in the future.
Well, thank you so much. It certainly, I love getting to hear. I think we need more in this country of dialogue that can be different and civil and a full, true discourse. And so it was really enjoyable to get to just explore this with you.
Okay, Lindsay, thank you very much. It's time for me to go to the grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
It appears that I made a mistake.